Welcome to Part 3 of our detailed reading of the Digital Personal Data Protection Act, 2023. Please check the Part 1 to get an overview of the various chapters in the DPDP Act and Part 2 for detailed review of Chapter 1. In this video, we'll be reviewing Chapter 2 of the Act, covering its key sections and compliance structure. As discussed in the Part 1 video, the DPDP Act 2023 is organized into 9 comprehensive chapters, and scope of this video is Chapter 2, referred to as Obligations of Data Fiduciary by the Act. As discussed in Part 1, Chapter 2 on the Obligations of Data Fiduciary includes 7 total sections, 2 grounds for processing, 9 legitimate use scenarios, an age threshold of 18 years, 2 additional roles for significant data fiduciaries, and 2 compliance checks. First, let's look at Section 4, which is relating to grounds for processing personal data. Subsection 1 of Section 4 establishes that personal data may only be processed according to the Act's provisions and for a lawful purpose, based on the data principal's consent, or for certain legitimate uses. Per subsection 2, lawful purpose means any purpose not expressly forbidden by law. Next is Section 5, which is relating to notice given to data principal. Subsection 1 of Section 5 dictates that any request for consent must be accompanied or preceded by a notice. This notice must inform the data principal of the personal data to be processed, the purpose, how she may exercise her rights, and the manner of making a complaint to the board. As per subsection 2, for consent given before the Act's commencement, the data fiduciary must give a notice as soon as reasonably practicable. The fiduciary may continue processing data unless the data principal withdraws consent. Subsection 3 of Section 5 ensures that data principal can access the notice content in English or any language listed in the 8th Schedule of the Constitution. Section 6 is all about consent from data principal. Subsection 1 of Section 6 defines valid consent as free, specific, informed, unconditional, and unambiguous, signifying agreement through a clear affirmative action for a specified purpose. Per subsection 2, any consent that infringes the Act is invalid to that extent. Per subsection 3, requests for consent must be in clear language, offering access in English or any scheduled language, and providing contact details for a data protection officer or authorized person. Data principals have the right to withdraw consent with comparable ease to how it was given, as per subsection 4. As per subsection 5, the data principal bears the consequences of withdrawing consent, but withdrawal does not affect prior legal processing. Per subsection 6, upon withdrawal, the data fiduciary must cease and cause its data processors to cease processing the data unless authorized otherwise. Subsection 7 says consent can be managed through a consent manager. Subsection 8 says consent managers are accountable to the data principal and, as per subsection 9, must be registered with the board. If a question about consent arises in a proceeding, the data fiduciary is obliged to prove that notice and consent were properly given, as per subsection 10. Section 7 provides details of certain legitimate uses. Subsection A of Section 7 outlines certain legitimate uses for processing personal data, including data voluntarily provided for a specified purpose, where the data principal has not indicated otherwise regarding its use. Per subsection B, processing is a legitimate use for the state and its instrumentalities to provide subsidies, benefits, or services, provided the data principal previously consented, or the data is available in digital form or subsequently digitized, and processing follows government policy or law. As per subsection C, legitimate uses include performing functions under any law for the state or its instrumentalities, protecting India's sovereignty and security, per subsection D, fulfilling legal disclosure obligations, and per subsection E, complying with court judgments or orders for contractual or civil claims. Section 7 continues to outline legitimate uses, such as responding to a medical emergency as per subsection F, or providing medical treatment during an epidemic as per subsection G, or public health threat as per subsection H. Subsection I is regarding employer using privacy data of an employee, which is considered as legitimate use to safeguard from loss of liability. Section 8 covers the general obligations of a data fiduciary. Per subsection 1, they are responsible for carrying out duties under the Act, even if a data principal fails to. Per subsection 2, this includes compliance with the Act and rules for processing done by a data processor on their behalf. Per subsection 3, the data fiduciary is required to ensure completeness, accuracy, and consistency of the personal data processed. And they are required to implement appropriate technical and organizational measures for compliance with the Act and rules, as per subsection 4. Per subsection 5, they are also required to implement security safeguards to prevent any personal data breach. The data fiduciaries are required to intimate both the board and the affected data principal in case of any breach as per subsection 6. Subsection 7 requires data fiduciaries to erase personal data in case the consent is withdrawn or the purpose is met, unless required to retain by any other law. To determine if the purpose is no longer served, per subsection 8, the data principal has not approached for the purpose or has not exercised any other rights. Per subsection 9, the data fiduciary is required to publish the contact information of the person responsible to answer any questions. An effective grievance redressal mechanism has to be implemented as per subsection 10. To determine the period of not approached, the period for which the data principal has not initiated contact for the purpose electronically or otherwise, as provided by subsection 11. Section 9 is all about processing of personal data of children. Subsection 1 requires that before processing personal data of children or person with disability, a verifiable consent of parent or lawful guardian needs to be obtained. Subsection 2 prohibits process of data that has detrimental effect on the well-being of a child. Tracking, behavioral monitoring, or targeted advertising pertaining to children are prohibited as per subsection 3. For prescribed classes of data fiduciaries or prescribed purposes, subsection 1 and 3 are not applicable as per subsection 4. Per subsection 5, central government may relax the age requirement for exemption from subsection 1 and 3 through a notification. The last section of this chapter, section 10, is relating to additional obligations of significant data fiduciary, also referred as SDF. Per subsection 1, the central government may notify any data fiduciary or a class of fiduciaries as significant data fiduciary after taking into consideration factors like volume, sensitivity, risk, impact, security, etc. Per subsection 2, the significant data fiduciary is required to appoint a data protection officer who represents the significant data fiduciary based in India, responsible for highest management, contact for grievance redressal. The significant data fiduciary is also required to appoint an independent data auditor. Further, under the same subsection, the significant data fiduciary is required to conduct periodic data protection, impact assessment, and periodic audits. We recommend the Calpi Quiz app, available on the Google Play Store, to test your knowledge of cybersecurity and the DPDP Act. The app offers various levels of difficulty and interactive assessments to improve your awareness. Thank you for watching this video relating to the raw reading of the DPDP Act. Hope you are now know more about the first chapter of DPDP Act. This was the 7th video in this series released by DPDPA Mentor.in. Please visit our YouTube channel, DPDPA Mentor, as well as our website, dpdpamentor.in regularly to check out other informative resources. Wishing you a successful DPDP Act implementation.